Hello, everyone. Welcome to the webinar today about the Indian Patent Prosecution Services and Form 27. I would like to welcome our panel here, Dr. Sebastian Türmer, who is the head of the Global IP Infrastructure, Giesecke+Devrient GmbH, Ms. Nidhi Gupta, who is a partner with one of the renowned law firms, AILegal Consultants. Myself, I'm serving as the CEO of Concur IP Consulting Private Limited, which is a Questel company. With respect to today's agenda, we'll start with the introduction of Giesecke+Devrient first, and then Questel, followed by AILegal. We'll give you a brief overview of working with Giesecke+Devrient over the past few months. We will then take feedback from Giesecke+Devrient about working with Questel and AILegal. Further, we'll also talk about the Questel and AILegal's collaborative advantage if the client would like to work with us on the Indian patent prosecution system. And last but not the least, we'll also shed light on the Form 27, the requirements and how Questel team can support you to have a streamlined process to file Form 27. So I hand it over to you, Dr. Sebastian, if you would like to give a few words about the G+D and yourself, please.
Welcome also from my side. Maybe a few words first to G&D. G&D makes the lives of billions of people more secure. We develop innovative products and solutions for securing payment processes, identities, connectivity, and data, with more than 160 years of experience and new passion every day. As an international technology group and traditional family business with over 12,600 employees in 32 countries. As you see, we have digital products as well as physical products. In Germany, we are well known for our banknotes, but we also provide eSIM subscriptions, for instance. So it's a wide technical field, as you see. And I am a patent attorney, and currently I'm heading the IP infrastructure team in the patent department of G&D, and my responsibility includes the management of external agents. And this was the starting point of our of the collaboration with AILegal.
Thank you, Dr. Sebastian. So we move over to the fact about how Questel and AILegal collaborated. So to do that, I would invite Nidhi Gupta, who is the partner at AILegal, to provide her introduction.
Hello everyone, a very warm welcome to this webinar. I am Nidhi Gupta, a practicing attorney in India for the last 10 years. I am grateful for this opportunity today to introduce our firm, AILegal Consultants, to you all. AILegal has been set up with a clear vision in mind, and that is to provide a transparent platform for all the global business entities who are having business operations in India, or who are looking forward to enter into the Indian market, or who want their IP assets to be practiced within the country. We are dedicated to provide them with a clarity and transparency when it comes to the Indian IP law requirements. We are dedicated not only to provide a quality product, but also majorly in reducing the time involvement of our clients in most of the tasks. For this goal, we had collaborated with Questel, a leading IP company, which helps us to deliver the best of the technical solutions, while we on the legal side work with the Indian Patent Office, yet all of that at a competitive pricing. In that event, I would ask Nitin to shed more light on the Questel and AILegal collaboration. Please, Nitin.
Yeah. Thank you, Nidhi. So Concur IP is an intellectual property services provider firm established in 2015. In 2018, we were fortunate enough to be acquired by the Questel group, and this is when we have been serving our global clients across US, Europe, and Asia. The team at Concur IP comprises of 25 patent agents, Indian patent agents. However, our team is very, very well versed with the US prosecution, with the EP prosecution. They also understand how to go through the PCT search reports, etc. Now, combining the knowledge of global prosecution and applying that itself with the Indian family patent prosecution, we are able to help our client not only in delivering a quality work product when it comes to reply to the FER, but also save a lot of time for the client because we do not ask them for any opinion of how to reply to the office section. We first prepare it, send it over to them, and ask them for only their review. So the Concur IP basically provides the technical expertise, and being working with all the foreign companies already and understanding the prosecution of different jurisdiction, they're providing that support. With AILegal, they take care of all the legal requirements with the IPO. So this collaboration together is providing the necessary efficiency and the cost advantages to our client.
So one of the finest examples of this Questel and AILegal collaboration is working with our esteemed client, Giesecke+Devrient. Recently, we took over representation of about 200 cases of G+D Indian patent portfolio. We assessed their data, cross-checked their data as against the IPO records, and provided them advice on their requirements and document base. Our team diligently got hold of the immediate deadlines just after the representation. To be precise, the representation was over around December 2023, and right in the month of January and February, our team adeptly handled 10 to 12 hearings in the patent matters before the controller. And I'm proud to say that out of those, 9 matters have already been granted. While we were taking this representation, we were not behind the client. In fact, we coordinated with the erstwhile agents to obtain the file wrappers of the unpublished matters so that it was less of a hassle for G+D, but more the burden was taken up by AILegal. And all of this, while we taking the representation, we did it at no professional charges. And all the jobs for the administrative tasks have been charged at a minimal cost. On that note, I am delighted to invite Mr. Sebastian to offer and share his first-hand experience in working with our team. And for that, I do have a set of questions ready for Mr. Sebastian, if he could answer and share his feedback with the viewers today. So at the outset, first that I would like to ask you, Mr. Sebastian, is that what initially prompted you to think of changing your representation for your Indian patent cases?
Nidhi, we were seeking a better option that could offer more consistency, responsiveness, and cost effectiveness. Our goal was to streamline the Indian prosecution process, allowing our team to focus more on their core work without getting overly entangled in procedural complexities.
So, Mr. Sebastian, when it comes to responsiveness and consistency, I would like you to describe the level of communication and responsiveness that you received from our client and from our team.
Generally very high. I would even say that we didn't notice the different time zones between India and Germany. As you know, when I tried to reach you in the evening, in the German evening, then you were still available. So that's really amazing. Good job.
Thank you, Mr. Sebastian. And so, are there any specific obstructions that you were facing, and how did AILegal and Questel collaboration help you out in overcoming those obstacles?
Yeah, your team has been instrumental in navigating our portfolio, and particularly in procedural challenges with respect to IPO.
Yes. So what do you think, Mr. Sebastian, is the most valuable aspect of our services that we are offering to you?
I think it's your workflow, when you provide us with a well-drafted response without first seeking our inputs. Our attorneys' workload is thus considerably reduced in as much as they just need to review or provide only additional comments from their end.
Yes, Mr. Sebastian, that was in fact our major goal, and that is the main reason behind this collaboration. And our vision was to reduce your involvement and time on those tasks. When it comes to cost effectiveness, Mr. Sebastian, how would you rate our services in terms of cost effectiveness and being reasonable to you as compared to your other alternatives that you might have considered?
It is quite reasonable, specifically when it comes to administrative tasks. Also, on the technical side, given the substantial work that our team takes care of, I would say you are competitive.
Thank you. And any improvements or suggestions that you have for this collaboration to move forward while we are working on your portfolio?
In general, we are quite satisfied with our collaboration so far, but we believe there's always room for improvement. However, most of the room for improvement in the Indian jurisdiction is, in my opinion, on the PTO side. So we are looking forward to the day when the Indian PTO goes fully digital and stops asking for paper copies.
Yeah.
We are all looking for that day, Mr. Sebastian.
Yes,
Yeah.
Sebastian. In fact, it is really moving forward. Post-COVID, a lot has changed, and I hope in future more will be streamlined on the PTO side. Yes. Thank you, Mr. Sebastian, for your very well positive feedback, and looking forward to working with you in a more seamless manner in future.
Thank you.
Yeah. Thank you very much. So I think this is a moment where I will take you to the process of how Concur IP and AI legal process or the collaboration is working. So I think the very first step is to draft a patent application, or in fact, before that, to conduct a search. So if the client require us to draft a patent application or conduct a patent research, our team is very much capable of doing that if it's an ordinary application in India. However, if the client is entering in a national phase and it's not a first file in India, and the client just instruct us to file an application that they have already filed elsewhere and they're entering the national phase, then the very first step is to file the application and to perform the pre-filing review, assemble all the filing forms, and then do the post-filing procedures. So I think it's better that since it is done by the law firm, so if Nidhi, you would like to speak a bit about how do you take care of the pre-filing review and what you do at the filing step and what exactly you do with the post-filing reminders, etc., please.
So when we first receive the filing instructions from the client, if it is an ordinary application, we cross-check that all the documents are in place. It is as per the, so we draft it according to the Indian format and then proceed with the filing. But when it comes to PCT national phase filing, what we need to ensure is that the application in India should be in consonance with the one that is at WIPO. So we perform a thorough data verification and we inform the client in case we observe any discrepancy. All of this review is done at the pre-filing and the filing stage so as to ensure that once the application has been filed and it moves later, we can minimize the level of objections that we might receive from the patent office later. Once the filing is done, we diligently track all the applications, and in fact, if there is some delay at the end of the client, for example, if they are not able to provide us due to some reason the proof of right or the POA, we file it at no additional cost, provided it is provided to us within a month or 2 months or so. These are the steps that we take, that the application is filed in a comprehensive manner to minimize objections at a later stage and also to assist our clients in minimizing their administrative costs.
Thank you, Nidhi. So the very next step, if the request for examination has already been done, and let's say the Indian Patent Office issues an FER, or at a later stage, maybe a hearing notice. What we have observed with most of the law firms in India, was that FER is obtained from the Indian Patent Office, or hearing notice is obtained. They try to connect with the client and provide the information to the client and ask the client about their opinion for how to respond to that office action. This is one step we have tried to change so as to save the client's time, or in fact, for that matter, their outside counsel time, if it coming through their outside counsel. As I mentioned previously, Concur IP has a team of patent agents who have been drafting and prosecuting applications both in US and Europe as well over the last 12 years. We have experience of doing the global prosecution. The first thing that we will check is if the Indian application in question has a US member, has an EP member, or there has been any international search report regarding the same. Our team will review the US prosecution, our team will review the EP file wrapper, our team will also review the PCT search report. Based on how the prosecution has progressed in the other jurisdiction, and based on the rejections issued by the examiner in India, we then develop a strategy. If we have to amend the claims, we amend the claims. If we have to, build up some arguments that we have to present in front of the controller, we build up those arguments that we have to present in front of the controller. We collate all that, we frame a response, and then we send it out to the attorney at the client's end or to the outside counsel for just reviewing that. Let us know if they agree with what we have prepared, and then we'll take it from there. So this whole process at least provide 50% to 70% savings on the client involvement about letting us know what to respond and what not to respond, because we do have the technical expertise to do that. So particularly again on the FER, our team drafts the response, we do the claim amendments, the clients share their review, and we file the FER. It could enter into 2 stages from that. It can either go straight to grant, or if the controller is not satisfied, they're gonna issue a hearing or a second FER. Even on the FER, we again review all the objections. We prepare the strategy in the very same manner as I just described. Our team attends the hearing in front of the controller. Now, while we attend the hearing, we do our homework pretty well. If we have to prepare claim charts, if we have to prepare certain embodiments that we have to present to the client, if we have to show where exactly the claim is substantiated in the specification, we take out those excerpts, we prepare everything before, and during this virtual meeting, we present everything in front of the examiner. We have been, in fact, given really great feedback by the Indian controllers that they have never seen the way we are presenting our arguments in front of them by preparing the claim charts of how we are arguing that our position is substantiated. Post the hearing, based on the discussion with the controller, we then prepare the written submission ourselves, and we send the written submission for the client for a final review. And once the client reviews the same, within the 15 days from the hearing, which is the deadline for filing written submission, our team files the written submission. And so far, our track record is 100% grant after filing the written submission. A very interesting requirement in the Indian Patent Office is a Form 3. So again, Nidhi, I would like you to comment on both the different sections, Section 8(1)(b), which is the Form 3 that has to be done on a regular basis, and then the next one, which is specifically asked by the IPO, which is the Section 8(2). So how do we delve into it? And again, how do we save clients' time when it comes to the Section 8 requirements? Nidhi, over to you.
Yes, Nitin. So when it comes to Section 8(1)(a), that is the initial Form 3, which is to be filed within 6 months, that we are receiving from the client the data and filing the same with the IPO. But now when it comes to Section 8(1)(b) requirements, that is the filing of an updated Form 3, which needs to be filed within the 6 months of any important update or a status change. For example, if there is any new corresponding application which is filed in the same patent family in a country other than India, that needs to be informed to the Indian Patent Office within a period of 6 months. This is a very important compliance, although it is a no fee requirement for the Indian Patent Office, but many a times it is taken lightly. Our team diligently monitors all the Form 3 requirements for our current applications. We send timely reminders to the client, but the work is essentially first done at our end. For example, if there is a previous Form 3 filed and we are somewhere now 5 months after that, we check the global dossier, we consider the previous Form 3 filed, we take out all the updates from our end, we check the USPTO, the EP, and the global dossier and incorporate all the updates, and then finally prepare a Form 3. Once the Form 3 is prepared from our end, we then share it with the client to verify if there is any other filing or a new filing which is not incorporated therein. The client provides their information and then the Form 3 is filed with the Patent Office. So here again, most of the updates are already found by our team and incorporated, and later on it is only shared with the client for a final approval. Now, when it comes to section 8.2, this is not a mandatory compliance, but this is something which the controller generally asks at the time of FAR, or he might request the patent applicant to file the section 8.2 details, that is with respect to the patent prosecution in the other countries. Now here also we realized that the clients sometimes face a challenge in collating all the documents from the respective prosecution offices and then share it with the respective local agents. Here also our team downloads all the publicly available documents on the prosecution patent site and from the various patent offices like USPTO, EP, collate all the information, and rather than just submitting it with the controller in a rough format, we formatted it properly. We provide a good index for the ease of the controller to go through all the prosecution stages and see how it is being dealt with in other countries. One more thing we noticed is that sometimes the priority or the prosecution documents are in a language other than English. If requested by that client and the client is not able to procure the translations, then we do offer translation services also to our clients, machine translation services, and then submit the said documents to the Patent Office. Yeah.
Thank you. So the statement of working for patents, Form 27, which is one of the most important requirements from the Indian law perspective. Nidhi, again, I would like you to shed light on this because this is really coming up, right? So this has to be started to file from April onwards.
Yes, Nitin. So Form 27 is a crucial requirement in India, as most of our global clients are aware of, and it's a debated topic, yes, because clients face challenges and they consider that this is an unnecessary hassle that the Patent Office in India has imposed upon them. But in order to simplify the process, we have now a set of questionnaire. But before we submit that share the questionnaire with the client, what we do is we study our client's Indian patent portfolio. We extract all the details at our end. We prepare an Excel sheet. We take out the current status of those patents, and then we share that list with the client for an approval. And in case they would like to comment upon if they are pursuing those patents or not, if they are wishing to abandon them, or if they are wishing to pursue them, they give a cross and a final approval to that. After that, according to the patents for which Form 27 is due for that particular year, we share a basic questionnaire with them in an Excel format wherein they can simply provide an input in one line as to what are the requirements, for example, whether they are working the patent or not. And if they are working, then an approximate revenue, because that needs to be drafted in while we file Form 27 on their behalf. But when it comes to patents, in most of the cases, for example, if they are not worked and the clients have not provided any reason behind it, then we also come forward with some suggestions which they can put in for the reason of non-working of their patents in India. Once this questionnaire is finalized, then we prepare the Form 27 and file the same on their behalf. All of this is done at a very minimal cost. We provide concessions to our clients. Also, we do offer reminder services at no additional cost. We do send timely reminders to our clients, and we are very we can customize whatever the client's requirements are, and accordingly we go and move ahead in Form 27. So last year we filed Form 27 for most of our clients, and in fact we received a positive feedback. For example, I would just like to mention there was one case wherein the client had provided us the inputs, and while we were comparing the data and observed the previous Form 27, we noticed that there are certain licensees also in that particular patent. So we informed the client that there are 2 licensees who also need to furnish Form 27. So kindly let us know if we should file the Form 27 on their behalf as well. So the client was very happy because we checked the previous data and we came forward and informed them of this fact. Right.
Thank you, Nidhi. Last but not the least, the key word is communication, right? We have experienced with Questel's global client who are working with the Indian law firms. So what they need to do, they need to send out an email to their law firm, wait for 24 or 48 hours to seek a reply. We are trying to change that entire responsive time frame. For most of our clients, including Dr. Sebastian, we allow them and we tell them that they can add us on their Microsoft Teams. We dedicate one single point of contact to each of our clients, and they are authorized to reach out to us on Teams itself if they are looking for a quick answer or an urgent answer to an impending question. Also, our TAT to reply to any of the emails coming within the working hours is the same day. If it's coming over the night, like it's coming from the US, the very early morning from India will reply so that you have an answer before you start your day, the very next day. So we are actually providing more of a personalized interaction with the client. We are understanding their needs, we are understanding their pain points, and we are trying to solve that impending problem of communicating with the Indian law firms. Again, our goal is to streamline the entire Indian patent prosecution system by not only delivering the quality, but also to curtail down the unnecessary charges. While sending you just an office section has been received from the patent office, we are not going to charge a $100 just for informing the same. If we are not doing substantial work, we do not charge for that. Sending you a reminder that something is due, we do not charge for that. We charge only when a substantial work is done, when we are supposed to charge for our technical knowledge or for our effort that we are putting in. That's all from today's webinar. I really appreciate all of you joining, and I would now welcome any questions that you may have, and we'll try and answer those. So there is a chat box where you can type your question, and we'll be very happy to answer the question. Great. So far, I do not see any questions from the audience. Again, we thank you all very much for attending the webinar. You all will be receiving the broadcast, and if you have questions even later on, if you would like to receive our pricing list, if you would like to receive how we are working throughout the mechanism of the Indian patent prosecution, we'll be more than happy to connect and provide more information to you. Thank you very much for joining today. Thank you.